The International Criminal Court is now in session.
Good morning, everyone. May I ask the court officer to call the case? Anyway, this is in the case of the prosecutor versus, we'll start with the appearances. Could I ask the parties to give their appearances?
Much obliged, Madam President. May it please the court. I'm Samuel Wong, and together with my co-counsel, Mr. Jeremy Chai, we represent the Office of the Prosecutor. I will address your honors for 13 minutes on the first two issues relating to the jurisdiction and admissibility. And Mr. Chai will address. Madam President, you appear to have been muted.
Excuse me, counsel, I'm first asking just for the appearances of the parties. So if I just may have the name of your team, the names of your team, and I will then ask the defense to also present themselves before we go into the actual submissions. Thank you.
Certainly. Madam President, we are from N37, Team N37, and myself, Mr. Samuel Wong, and my co-counsel, Mr. Jeremy Chai, we are from the prosecution.
Thank you. May I ask the appearances for the defense?
Certainly, Madam President, and may it please the court. I am Usman Sheikh, and together with my co-counsel, Mr. Rashid, we appear on behalf of Lord Blaze and the Defense Counsel.
Thank you. Prosecution, you may now proceed with your submissions.
Madam President, your honors, may it please the court. I am Samuel Wong, and I will address this court now for 13 minutes on the first two issues relating to the jurisdiction and admissibility of this case. My co-counsel, Mr. Chai, will address this court for the remaining 12 minutes on the remaining two issues on the interests of justice and Lord Blaze's individual criminal responsibility. We reserve 5 minutes for rebuttal. Your honors, this case arises from the enslavement of earth bowers at Nsereko, disguised as voluntary educational programs. They were forced to work, mistreated, and deprived of their fundamental liberties. And at the center of all these lies the President of Fire Republic, Lord Blaze, who oversaw the carrying out of these deplorable acts. Today, this court is not asked to pronounce on his ultimate culpability, but only to decide if there are reasonable grounds to commit this case to the confirmation of charges stage. And what this requires is the existence of some facts or information that will satisfy an objective observer that a crime of enslavement may have been committed. This was held by this court in its 2008 Bamba decision and its 2012 Tagenda decision. With that, I begin with my first submission, that this court has the jurisdiction to hear the case. Now, the most contentious facet of jurisdiction between the parties is subject matter jurisdiction, your honors, which requires the crime of enslavement be made out on reasonable grounds, pursuant to Article 58, 1A of the Rome Statute. And there are three elements to this crime found at Article 7, 1C of the elements of crime. We say that all of these elements are made out on the facts. They are: one, an exercise of powers attaching to the right of ownership over the detainees; two, a widespread or systematic attack directed against a civilian population; and three, the perpetrators knew that their conduct was part of this attack. Now, the dispute today is likely to be over the first element, the exercise of ownership powers. And to find such an exercise of ownership powers, the underlying question is whether there was a substantial degree of control exercised over the victims, such that they were reduced to mere commodities ready to be used and disposed of. This was described by the appeals chamber in King. Now, to answer this question, the courts consider several factors, which include: one, the control of the detainees' autonomy; two, the control of their physical environment; three, measures taken to prevent their escape; And fourth, and crucially, the exaction of forced labor. Your Honors, the prosecution accepts that in all kinds of detention centers, there will be some form of control exercised over the detainees. However, what makes the present case amount to the crime of enslavement is the exaction of forced labor that was carried out under inhumane working conditions. And we say that this precisely depicts the exercise of ownership powers. If detainees are made to work, Your Honors, then they must at least be ensured reasonable working conditions. This was held by the trial chamber in its 2003 Chrono-Yalach decision. And some indications of the standards of minimally acceptable working conditions include: 1, the detainees shall be provided with food and drinking water, as stated in Article 5 of the Additional Protocols 2 to the Geneva Conventions. And 2, they must have at least 1 rest day per week, as stated in Rule 102 of the 2015 United Nations Nelson Mandela Rules. On the facts, neither of these standards were met. Your Honors, if I may refer you to paragraph 12 of the facts and see that you're with me. We first see that the detainees were forced to work 12 hours a day, every day of the week, with only a 30 minutes lunch break. This occurred over the span of 7 grueling months. And at the last line of paragraph 12, Your Honors, we clearly see that they were sometimes deprived of food and water. Now, this is already sufficient to establish grave breaches of acceptable working conditions. But Your Honors, the detainees here were in fact subjected to worse treatment, where they were too weak to work. Instead of affording them rest, like all human beings require, they were cruelly punished. Now, they were forced to stand outside in the snow, sadistically in front of a picture of Lord Blaze, while BNS officers merely stood by and watched. Your Honors, such inhumane treatment confirms the extent to which the detainees were reduced to mere commodities, only to be exploited for uncompensated labor and be at the ready disposal of BNS officers. Thus, we say that the present case has given us at least some facts or information that will satisfy an objective observer that a crime of enslavement may have been committed. Now, in my remaining...
Excuse me, Counsel, I have a question. Was there any advantage that they received in return for this labor? And if so, in what sense does that affect possibly the finding on whether what happened constitutes enslavement?
Madam President, on the facts, Minister Azila has painted a rosy picture at paragraph 9, where she states that detainees will be afforded their detention to be reduced by 2 months. This is seen at line 7 of paragraph 9. Now, however, this does not detract from the finding of enslavement, because the detainees here were not given a real choice as to the forced labor. Now, they were faced with 2 choices. 1, a detention, and 2, participating in this forced labor regime. And on the facts, they were not given a fair trial as to whether they were prisoners or convicted of any crimes. Hence, we say that when they were subject to forced labor, they were not given any real choice. And we say that this finding of involuntariness precisely shows the extent to which they were stripped of their free will and the substantial degree of control exercised over them. Now, if that addresses Madam President's concern,
yes,
I will now, thank you, Madam President. I will now, in my remaining time, show this court why this case is also admissible, because the defense's case, the defense's challenge to admissibility under Article 17(1)(c) must fail. Now, the crux of the dispute today is whether the amnesty granted to Lord Blaze can be invoked before this court. And Your Honours, it is important to note that the Rome Statute does not have an express provision dealing with the issue of amnesties. But the ICC, in its recent decisions, such as Gaddafi, have dealt with them in relation to this specific provision that the defense is solely relying on today. And there are two cumulative requirements to Article 17(1)(c), and the defense bears the burden of proof in their challenge. Therefore, we make just one point here, that Lord Blaze had not been tried for the acts of enslavement at Nsereko, because the amnesty granted to him does not constitute a trial. Now, a trial under Article 17(1)(c) entails a judgment on the merits, leading to a final conviction or acquittal of the accused. This was consistently held by this court in its 2008 Bemba decision and recently upheld in its 2019 Gaddafi decision. Hence, applying this interpretation, we say that Lord Blaze has not been tried by the domestic court. Now, it is useful here to refer to the case against Mr. Bemba Gombo, where this court was similarly faced with a challenge to admissibility on the same provision. There, the defense argued that Article 17(1)(c) can be made out because a senior investigating judge of the domestic state had already tried Mr. Bemba. However, this court dismissed that argument for two reasons. One, that a trial could only occur before a criminal court. And two, all the senior investigating judge did was to consider the sufficiency of evidence and not actually pronounce on the merits of the case. Hence, in the present case, Your Honours, we say that the defence's case must be dismissed for two reasons similarly. First, the conditions on which the amnesty was granted here were entirely unrelated to an adjudication on the merits of the case. Now, at paragraph 20 of the facts, Your Honours, paragraph 20 lays down the conditions on which the amnesty was granted. And these two conditions are disarmament and public apology. These have nothing to do with an analysis of whether a crime has been committed, much less the crime of enslavement. Secondly, and more importantly, the domestic judge here had not even considered the relevant evidence of the acts of enslavement at Nsereko. All he had applied his mind was whether the conditions on which the amnesty was to be granted were made out on the facts. Accordingly, we say that Lord Blaze has not been tried by the domestic court, and this court must be able to intervene to pronounce on Lord Blaze's guilt for committing crimes against humanity. Your Honours, the first and most basic Nuremberg principle is that anyone who commits a crime under international law shall be made responsible and liable to punishment. Thus, my co-counsel, Mr. Chai, will now show this court why Lord Blaze is indeed individually liable for the crime of enslavement, and unless I may be of any further assistance. This concludes my submissions.
Thank you.
Excuse me, may I ask you?
Certainly, Your
shortly?
Honor.
Yeah, I understand you discussed or analyzed, argued the enslavement definition is clear, but I think the court may deal with only Article 5 or the four types in Article 5 of Rome Statute. Then individual act we understand. Nevertheless, I think we need maybe other aspects as well. What do you think about that?
Your Honor, could I clarify your second question, if there was a second question?
Second, just one question.
And that is regarding why we can rely on the elements of crime, which states down clearly the elements of the crime of enslavement.
enslavement, the definition was clear. Nevertheless, I think another conditions
Your Honor,
you didn't mention at all. That's why I asked you.
Your Honor, are you referring to the other factors of enslavement that can be made out on the facts as well?
No. Enslavement is just recognized as individual act, but so only individual act doesn't consist of core crime, I think.
If I may clarify, I think what my colleague judge is trying to get at is whether we need to take into account contextual elements that apply in this particular case.
Yes, Madam President, and Your Honor, yes, we do need to take into account these contextual elements, and we submit that all of the contextual elements are made out on the facts. Now, Your Honors, I note that my time is running out. If I may address this point in rebuttal so that my co-counsel can address this court on the remaining two issues. Much obliged, Your Honors. I shall now yield the floor to my co-counsel.
Thank you. Please proceed.
Madam President, Your Honors, may it please the court. As earlier introduced, I'm Jeremy Chai, and I continue the case for the Office of the Prosecutor. My co-counsel had earlier addressed this court of its jurisdiction, as well as the admissibility of the case. Now, for 10 minutes, I make the following two submissions. First, the defense's challenge to the interests of justice must fail for lack of a legal basis, and alternatively, because the present case is not detrimental to the interests of justice. And secondly, that there are reasonable grounds to believe that Lord Blaze is individually liable for the crime of enslavement as a superior overseeing that enslavement. Your Honors, I begin with my first submission, and we make 2 points here. The first point is that the decision on the interests of justice is one for the prosecutor to make. This is borne out of the very wording of Article 53(3) of the Rome Statute. It only provides for the pre-trial chamber to review decisions of the prosecutor when the prosecutor decides not to proceed. It is only in this limited circumstance in which this court may review decisions of the prosecutor was confirmed by the pre-trial chamber in its 2009 decision in the situation in Darfur, Sudan, and by the appeals chamber last year in authorizing the investigation into the situation in Afghanistan. Therefore, the defense simply has no basis to challenge the case on the interests of justice. My second point is that even if this court finds that it can inquire into the interests of justice, the present case is not detrimental to it. This is because the current prosecution promotes that peace process. First, clarification 5 to the facts provide that the report of the Truth and Reconciliation Commission has been published. And secondly, we are not disputing the findings made by the Truth and Reconciliation Commission. Instead, what we have done is to build on the good work of the Commission through further investigations and then now taking the perpetrators to justice. This provides closure and finality to all affected parties, especially the victims. This aspect of justice, specifically criminal justice, can only be achieved by prosecution, and it does not interfere with the other aspects of justice sought to be achieved by the domestic peace process. Your Honors, a further reason why this case is in the interests of justice is that it is necessary in the interests of the victims. For nearly 2 years since the detention centers have been shut down, not more than a handful have come forward to speak about their experience. Now, this is difficult to reconcile with Minister Azila's assertion that the program is completely voluntary. Indeed, the only detainees that have spoken are the ones that have escaped to the Water Kingdom, far beyond the control and jurisdiction of Fire Republic. Your Honors, the inference to be made here is that the Earth-Bowers are either heavily traumatized or still face pressure of unpleasant consequences. In either case, the physical and psychological safety of the victims must be secured by ensuring that those responsible are held accountable. The present case is therefore in the interests of justice. I turn now to my second and final submission, which relates to Lord Blazer's individual liability for the crime of enslavement. Your Honors, the 7th Nuremberg Principle states that complicity in the commission of a crime against humanity is a crime under international law.
And so before you proceed, if I may ask, we read in the fact sheet that Lord Blaze apologized to the victims for the atrocities. Isn't that good enough?
Your Honor, an apology by itself is definitely not enough. This is because the Rome Statute still imposes on party states an international obligation to ensure that these most serious of crimes do not go unpunished. And that is why the current prosecution is necessary and is in the interests of justice.
Okay, proceed.
Much obliged, Your Honor. Now I turn to my second submission, which relates to Lord Blazer's individual liability. And in this regard, the 7th Nuremberg Principle provides that complicity in the commission of a crime against humanity is a crime under international law. And that is exactly what Article 28 provides for. Now, under Article 28b, there are 3 elements to hold a superior individually liable. They are 1, knowledge or conscious disregard, 2, effective control and responsibility, and 3, a failure to prevent or repress the commission of those crimes. Now, Your Honors, I will focus on the most contentious of these 3 elements, the mens rea requirement. Here, there are reasonable grounds to believe that Lord Blaze actually knew that Minister Azila was about to commit crimes against humanity in Nsereko. In the ICC Trial Chamber 2016 decision of Bemba, it was held that knowledge can be established through inferences made on indirect circumstantial evidence. Your Honors, here 3 different facts indicate Lord Blazer's relevant knowledge. First, in relation to his leadership position, he was the one that created the conditions that facilitated the commission of the crimes in the first place. As the President of the Fire Republic, he had signed the Anti-Extremism Executive Order, which vested power in Minister Azila to use the necessary means to end the potential threats to national security. After signing this order, Lord Blaze remained very much in control of the operations at those camps. If I may refer Your Honors to Exhibit 1 of the facts. It is evident at line 7 that Lord Blaze was kept updated with the number of people in the different camps. At line 8, that he had the power to order the release and relocation of the detainees. And further at line 15, that he was the one that had the final say in relation to the operations at those camps. Now, this point is also evident from Exhibit 2, where the authorization of delivery of specific materials later used by the detainees in their forced labor was issued from his office. Without Lord Blazer's crucial involvement, all of this would not have been possible. Now, the second of the 3 facts that we're relying on today relates to the logistics involved. Here, communications equipment such as letters and telephones enabled Minister Azila to communicate directly with Lord Blaze. This is again evident from Exhibits 1 and 2 of the facts. These 2 exhibits by themselves represent 2 instances of communication within 3 weeks. And in addition, they refer to at least 2 other instances. In line 10 of Exhibit 1, Minister Azila assured Lord Blaze that the report on Nsereko will be submitted by that month. And indeed, according to clarification 2, such reports were indeed submitted. Now, Exhibit, yes, Your Honor.
Exhibit one which you refer to, this very same 6 and 7, lines 6 and 7. Here we see Lord Blaze concerned about the overcrowding of the labor camp, and even advises on measures to mitigate the hardship there. Doesn't that negative means rare mental culpability? Doesn't that exonerate him of criminal responsibility that you are trying to put on him?
No, Your Honor. What we are trying to show this court is how Lord Blaze remained in control over the operations at those camps. And indeed, there is further evidence within Exhibit 1 and 2 to show that Lord Blaze actually knew of what was happening in those camps. For instance, Your Honors, at line 14, Minister Azira claims that she needed more men and supply. Your Honors, if this was a normal detention or even an education center, there is no need for more men. The phrasing suggests that the detainees were being used, and this was communicated directly to Lord Blaze. Your Honor, yes, Your Honor. Your Honor, you are muted.
Are we told what these other extra men we are going to do at the labor camp?
No, Your Honor, we do not know what exactly these men it is not communicated to Lord Blaze what exactly these men were working on, but that is not fatal to our case.
Maybe they were coming to do good work.
Yes, Your Honor. We submit that, Your Honor, I note that my time is up, if I may just answer your question. Much obliged, Your Honor. We submit that this phrasing, needing of more men and supply, must be read in context of Exhibit 1. And here, not only does Lord Blaze know that the detainees were working on something evident from line 11 of the facts, he further suggests that there is a threat of mutiny at line 10. Now, Your Honors, read in context, it is clear that Lord Blaze knew of the crime of enslavement being committed in these camps, although he doesn't know the specific work that the detainees were carrying out at those camps. But this is not fatal to the case, as the trial chamber in Prosecutor and Bemba has confirmed that there is no need for the superior to know the specific details of the crime. If that addresses Your Honor's concern.
Proceed.
This concludes my submissions.
Thank you very much. Defense team, you have the floor.
Much obliged. Madam President, Your Excellencies, and may it please the court. My name is Usman Sheikh, and together with my co-counsel, Mr. Rashid, I will be presenting the submissions in the defense of Mr. Lord Blaze before this honorable court. I will be taking a total of 18 minutes for the first 3 issues. That is how this court does not have jurisdiction, why this case is not admissible, and how a prosecution leading to trial is not in the interest of justice. Whereas my co-counsel will be taking a total of 7 minutes to prove how Lord Blaze's criminal liability cannot be made out on the merits. Before proceeding with the case, the defense clarifies that the order of its submissions today are based on the order of the submissions that the prosecution has opted for before this court. And in that regard, the defense will begin with counting the prosecution's first submission that the elements of enslavement as a crime against humanity are not made out in the present case. Your Excellencies, the defense disagrees with the allegations struck against Mr. Lord Blaze by the prosecution, who is a devout leader and is seen, not to mention by most, as a hero in his country for bringing peace to a region that is stricken with hostilities for nearly a century. The defense on the charge of enslavement agrees with the prosecution, at least to the extent of the definition that has been forwarded by the prosecutor. And in that regard, the definition is indeed the exercise of the right of ownership. However, the defense adds here that the ICTY in Kunarak trial judgment at para 542 explicitly lays out the factors that indicate the exercise of a right of ownership, which are forced or compulsory labor, restriction of autonomy and movement, as well as the accruing of some gain to the suspect or the perpetrator, which in our case is Mr. Blaze. Noting that the prosecution has not challenged the restriction of autonomy, the defense will now rebut two of these factors and prove how there has been no exercise of the right of ownership. In regards to the first element of the exercise of forced labor, the prosecution has rather conveniently relied on para 12 of the agreed facts, specifically on a statement made by one individual, Haru Rock, to substantiate its case. On this, the defense submits that there are two irreconcilable issues with Haru Rock's witness statement. First, the defense on behalf of the suspect, Mr. Blaze, has the right to examine the testimony of the witness as guaranteed under Rule 140 of the rules relating to procedure and evidence, which is rendered impossible since Haru Rock, as per para 11 of the agreed facts, has escaped to a third country. Second, this court at para 78 of its judgment in the Lubanga trial noted, and I quote, "A chamber must consider whether the evidence presented by the prosecution is corroborative of any other evidence." In the present case, it is an undisputable fact that there simply isn't enough evidence to corroborate Haru Rock's statement with other evidence, and if there was, it was the prosecution's duty to have done so in its submissions today.
Excuse me, counsel, I have a question. Does the ICC law allow for the presentation of even anonymous summary evidence at the pretrial stage?
Yes, Madam President. However, even if anonymous evidence were to be furthered, it must be noted that the right of Lord Blaze to cross-examine must be guaranteed not only under Rule 140 of the Procedure and Evidence, but also under Rule 67. That is, if the prior recorded testimony is in fact deemed admissible before this court, the prosecution and the defense both must have had the opportunity to question the evidence when it was being recorded. So Your Excellencies, the same is simply impossible. And in that regard, coming back to the defense's submission as per the Lubanga case, it is an undisputable fact that the prosecution cannot corroborate Haru Rock's individual sole statement with any other evidence. Therefore, this court can logically only find that Haru Rock's statement is inadmissible. And this would have the effect of rendering the prosecution's case in regards to the factor of standalone forced labor effectively empty and unmeritorious. Now, in regards to the second factor of the exercise of right of ownership, which is whether there was any gain accruing to the perpetrator, the defense notes that the prosecution has simply failed to prove what possible benefit could Fire Republic get from resorting explicitly to enslavement. And on that point, the defense submits that the present case is factually utterly at odds with cases where the courts have genuinely found enslavement to have occurred. For instance, in US against Paul, the Nuremberg Tribunal found the detainees labeled as productive units and were regarded as machines and not as human beings, and were even made to dig trenches and produce ammunition. In furtherance of this analogy, through reliance on para 9 of the agreed facts, the defense questions that if enslavement was indeed intended by Fire Republic, why then was it incentivized through a 2-month reduction in sentencing? Madam President and Your Excellencies, owing to the fact that the prosecution has not and cannot answer this question, the defense requests this court to decline the charge of enslavement since its legal test of the exercise of the right of ownership has not been made out.
So was the labor camp, the work at the labor camp voluntary?
Your Excellencies, thank you for your question. The defense submits that it is irrelevant whether or not the work at the labor camp, the alleged labor camp, was voluntary or involuntary, for the simple reason that the defense's submission is much broader in that regard. There was no labor camp and there was no forced labor inside the camps because there is no evidence to substantiate the claim that has been made by the prosecution. Now, the prosecution notes that, the defense notes that the prosecution has not grounded the contextual elements of jurisdiction over the non-existent crime against humanity. But the defense notes the willingness of the bench to inquire into these contextual elements. Accordingly, the defense contends that the alleged attack was, as required in Article 7 of the Rome Statute, not directed against a civilian population, nor was it systematic or widespread. First, The defense submits the most prevalent definition by the United Nations Commission on Crimes Against Humanity, which has stated, and I quote, "The words civilian population appear to indicate that crimes against humanity are restricted to inhuman acts against civilians as opposed to members of armed forces." This definition, coupled with para 6 of the agreed facts, which tells us that there have been violent armed clashes between Fire Republic and a separatist group called the ANG, forms our next submission, that there was an ongoing non-international armed conflict, hereinafter referred to as an NIAC, in the region. Your Excellencies, the course of conduct in question primarily relates to the arrests between 2015 to 2018, because it is these arrests that have a direct nexus with the fall of detention and the subsequent allegations of the crime against humanity of enslavement. On that, we submit that the existence of an NIAC justifies the course of conduct between 2015 to 2018 since, and this is the defense's crucial submission, these arrests were targeted, fundamentally directed primarily against members of armed forces and not against civilians, as is the requirement under Article 7.1 of the Rome Statute.
Including children?
Your Excellencies, there is again no evidence to corroborate the fact that there were children present in these detention centers and these re-education camps. There is in fact an allegation again leveled by Haru Rock. In that regard, the defense has already substantiated how his statement standalone cannot be admissible before this court. Your Excellencies, the Perisic trial chamber at para 83 noted, and I quote, that the attack must have been directed against the civilian population, means that the civilian population must be the primary object of the attack and not just the incidental victims. And in that regard, Your Excellencies, the defense submits that the attack could not have been systematic for the simple reason that even if there were incidental civilians in the arrests of 40,000 individuals during the commemorations, prosecutor against Kunarak at para 100 holds that a conduct which would be regarded as isolated when it is so far removed from the conduct otherwise in question. The conduct otherwise in question being the conduct that has already been justified by the defense as being arrest leveled against or directed against members of armed forces rather than civilians. Now we note that the gathering of these individuals at Black Mount, inclusive of ANG leaders, inclusive of Haru Rock as per para 11 of the agreed facts, at one point in time occurred just 2 months after extreme hostilities broke down in the region. And the circumstances were such that commemorations as an event in and of itself had never occurred in the region before. Therefore, an attack could not have been premeditated or preempted against the civilians that were incidentally present during the commemorations. Furthermore, Your Excellencies, the defense submits that the alleged attack could not have been widespread either. This court, in prosecutor against Laurent Gbagbo at para 224, found the attack to be widespread most recently, since the victims were A, targeted in various ways, B, they were targeted in various areas, and C, there were multiple crimes against humanity that stood proven, and not to mention over a period of more than 4 months. Madam President and Your Excellencies, the defense has already justified the course of conduct leading to the arrest of 40,000 incidental civilians that might have been there as coincidental. And in that regard, there are only 2 individual acts that the prosecution can logically question. One, the arrests of incidental civilians during the commemorations, and second, the coincidental creation of the detention centers. In prosecutor against Katanga at para 1130, this court determined, and I quote, that an attack must be exceptionally large in order to be characterized as widespread, which cannot be the case of a single offensive whose military objective is a one-off event. In our case, the single military offensive is a one-off commemoration that had occurred for the first time in the region and was not one that Fire Republic could have anticipated in order to be able to preempt a large-scale attack.
But the repression went on for 4 years.
Your Excellencies, respectfully, the hostilities and the NIAC occurred for 3 years between 2015 to 2018, and even less than that. And the agent submits that however the period may be, it simply is irrelevant to the widespread requirement because there is no establishment or the grounding of the large number of acts that are required for proving a widespread attack. And in any case, Your Excellencies, the prosecution has simply not contended the contextual elements of the jurisdictional requirement of this court, which is why the defense's submission must stand on its own.
Won't you take into account the separation of the earth powers language? It's not taught in the schools, banned everywhere. Isn't that part of the attack against the earth power people?
Your Excellencies, there simply is no evidence to suggest that earth power people, there is no quantification of a number as to how many civilians were in fact arrested by the Fire Republic state authorities. And in that regard, this requirement does not need to be met either, for the simple requirement as per Article 7.1 of the Rome Statute is that the attack must be primarily directed against a civilian population, which the defense has already proven is not the case at hand.
But the banning of the speaking of the language in schools is part of the repression, and those children in schools are clearly civilians, are not military people.
Your Excellencies, the banning of language and other derogations from human rights do not form part of the course of conduct that the prosecution has challenged before this court today. And the banning of language and other fundamental human rights violations that may have occurred do not have a nexus with the alleged enslavement that actually, as the prosecution alleges, has occurred within the detention centers. These are but separate events.
It's cumulative, it's contextual.
Your Excellencies, it may be contextual, but it was the prosecution's requirement, as was required under the statute, to prove that there was a causal nexus between these cumulative acts. However, in that regard, even if this court were to consider the requirement on its own volition, we submit that such a requirement is not made out. And in that regard, we proceed towards the second issue of admissibility. Noting the prosecution submissions, we have but two counters. First, that this case is inadmissible since Lord Blaze has been tried and investigated domestically for the purposes of Article 17, and the same forms a basis of a defense pursuant to Article 20, subsection 3 of the Rome Statute. In regards to the first submission, this court in para 12 of the trial and para 58 of the appeal judgment in the Gaddafi case stated unequivocally that the requirement of being tried pursuant to Article 17(1)(c) would be fulfilled when a decision attains finality and the suspect has been tried in a national court. The defense submits that Lord Blaze's criminality has been decided and has attained finality pursuant to clarification number 6 of the agreed facts, whereby the final judgment of the national court has already been made out.
What was it tried for, and what was he convicted of? For what offense was it tried?
Your Excellencies, the specific offense requirement is not the requirement of this court, as has been stated time and again. For instance, in the Gaddafi case at para 78, and for instance, in prosecutor against Francis at para 38, that the same conduct requirement to be tried before a national court requires the conduct to be tested by the national court to be of a similar or a substantially similar conduct and to fall within the material scope. In that regard, Your Excellency, we submit that Lord Blaze has been investigated thoroughly and also been tried before the national court in and outside the events that occurred within the detention centers, as can be seen in clarifications number 5 of the agreed facts. Now, Your Excellencies, we submit that the amnesties must stand and this case must be deemed inadmissible for the simple reason that this procedure, the amnesty procedure in itself, was undertaken upon an extensive discussion by ANG leaders and Fire Republic. And this was to apply equally, not to mention to both parties. And to this end, the defense notes the South African Constitutional Court's remarks on this notion, where it stated that at the end of the day, only the parties concerned are best equipped to determine what measures may be the most conducive for the facilitation of reconciliation and reconstruction. If the parties, including ANG, did not want the amnesty to be leveled to be availed by Mr. Blaze, the same could have been a provision under the peace agreement, which it simply was not. And in that regard, Your Excellencies, the defense also submits that the interest of victims have been made out before this court, which is why the prosecution's decision to not pursue with the prosecution, to pursue rather with the prosecution of Mr. Blaze must be reviewed by this court. Which, Your Excellencies, coming to the first requirement, the defense refers to this court's findings in the situation in the Islamic Republic of Afghanistan and para 35, where it noted, and I quote, that the scrutiny mandated to the pre-trial chamber in the proceedings is not limited to determining whether there is a reasonable basis to believe that crimes against humanity under the court's jurisdiction have been committed, but must also include a positive determination to the effect that investigations and subsequent prosecution would be in the interest of justice, including in relation to potential victims' interests. On the interests of victims, the defense submits that the interests have already been made out. For instance, Security Council Resolution 827 decided that the work of any international tribunal shall be carried out without any prejudice of the right of these victims to seek reparations for grave breaches of humanitarian law. Accordingly, this court and prosecutor against Lubanga recognized the importance of symbolic non-monetary reparations, which is also a question raised by the bench earlier on with the prosecution. Your Excellencies, Mr. Lord Blaze has not only apologized before the civilians and the Fire Republic and the Black Mount people, but that apology in and of itself is capable of forming a non-monetary and a symbolic reparation. For the simple reason that for the first time in nearly a century, a president of Fire Republic has come out and made a public apology. Knowing full well that Black Mount is a province stricken with violence, the defense submits that the potential victims that the prosecution stands for today have already declared their wants and needs within the peace agreement, and this prosecution does not have any victims to substantiate its case.
Was that apology genuine?
Your Excellencies, unless proven otherwise, that apology was far more than genuine.
We are told that he decided to appear before the Amnesty Commission in order to protect himself. It was belated.
Again,
belated stance is original, in order to protect himself against what is happening before this court right now against him.
Again, Your Excellencies, there simply is no fact to substantiate this allegation against Mr. Lord Blaze. And the mere fact that both the ANG leaders and Fire Republic have negotiated the peace agreement and that Lord Blaze's right to seek the amnesty was not explicitly set off or struck off within the negotiations should go to show that Lord Blaze has not availed the amnesty only to shield himself. With this, Your Excellencies and Madam President, the agent invites his co-counsel to further the submissions of the defense.
Madam President and Your Excellencies, may it please the court. We now turn our attention to the person accused of this crime, Lord Blaze, pursuant to Article 28B of the Rome Statute. The defense would now demonstrate that there were no reasonable grounds to believe that Lord Blaze is criminally responsible for the alleged crimes. The defense would prove A, there was no failure to exercise control on the part of the president as he was unaware and about the alleged acts that were going to be committed. B, he took all the necessary and reasonable measures within his powers at that time. Firstly, the defense submits that Lord Blaze was unaware of and did not consciously disregard information indicating that the crimes were being committed. To support our case, we shall draw persuasive authority from the ICTY prosecutor versus Halilovic, which provides in the paragraph 66 that the knowledge of a superior that his subordinates are committing or were about to commit cannot be presumed, but rather must be established through circumstantial evidence. In this regards, the factors to consider include the number, the type, scope of these illegal acts committed by the subordinates, and the time period during which these acts occurred, and whether these acts were widespread in nature. Furthermore, the judgment also covers the geographical element and the temporal circumstances, which says the more physically distanced the superior was from the scene of the crime, the more evidence which may be necessary to prove that he had actual knowledge of them. In seeing in paragraph 6 of the case facts, on September 2018, Blacknout witnessed frequent and violent clashes and between the Fire Republic and the ANG loyalists, which included armed violence as well. During the same month, Lord Blaze requesting the government through an anti-extremist executive order to monitor the situation with the sole intention to reestablish peace in the region, as seen in the paragraph 7 of the case fact. Therefore, these alleged acts committed by the subordinate occurred during a time of destabilization. Additionally, Your Excellencies, in this regard, ICTR prosecutor versus Nahimana mentions on paragraph 65 that if a conviction is based on an inference drawn from the circumstantial evidence, it must be the only reasonable conclusion that could be drawn from the evidence. The defense, Your Excellencies, challenges the strength of the evidence provided in Exhibit 1 in terms of drawing the only reasonable conclusion to be that Lord Blaze knew about the ongoing detention centers. However, all this evidence does is just points us towards the number of the individuals that were in the center, which would again not indicate that these activities concerning the crime of enslavement, as to the case facts on paragraph 11, mentioned that the center rig was the largest detention center in Fire Republic. That is another indication of the fact that it had the capacity to house many individuals. Additionally, Your Excellencies, seen in the Exhibit 2, the materials which were requested for and then authorized for at the center, it would be only indicator of these materials were needed for educational program. Let's connect the dot, as this is because the Fire Republic's economy is based on coal mining and metalworks, as seen evidently in paragraph 1. Therefore, making such an authorization of these materials for educational programs a convenient and rather a task of normality for the Republic. This, to Your Excellencies, does not indicate the crime of enslavement was about to be committed. As the defense submits, the circumstances of this particular case are of utmost importance, and the mental element under the Article 28B, Lord Blaze's primary concern was evident that pertaining to high number of individuals within the education center, he had requested Ms. Ursa to send 10,000 detainees, for making such administration easier. Additionally, Your Excellencies, during the conversation, the message as to what the detainees were doing was never delivered in the first place. That would also not indicate that there was no deliberate failure to obtain information and repress the commission of crime. Lastly, Your Excellencies, what prosecution has failed to acknowledge that as the following month after the report was delivered, the president decided to put an end to the conflict and ordered peace negotiation with the ANG leaders. Following this peace agreement, all detention centers were closed and all detainees were released. Concluding, the defense urges this court to declare that there are no reasonable grounds for the case to proceed any further. This concludes the submission of the defense. May it please the court.
Thank you very much. Prosecution, do you want to? Yes, you have the floor.
Madam President, Your Honors, 4 points in rebuttal. Now, as a preliminary point, we noted that just now, Judge Kazushige had queried us on the contextual elements of the crime of enslavement, and it is our position that all of these contextual elements are made out on the facts. And in this regard, there was a rather elaborate discussion on whether the population that was under attack in this context was of a civilian nature, and we submit that it was indeed of a civilian nature. Now, Your Honor had earlier queried the defense whether children, ordinary men and women of Baoist priests, were they also not considered civilians population? And in this regard, the defense takes an extremely strained and narrow reading of the facts, Your Honors. They fail to take into account the broader context of this attack, which is clearly made up on the facts at paragraphs 4 to 6 of the facts, as a 4-year-long repression of the Earth Bowers and denying them of their fundamental liberties. Hence, as the entire Earth Bower population was the object of this broader attack, there can be no question as to the widespread nature of the attack. Now, turning to my second point in rebuttal, this relates to the defense's attempt to cast doubt on Haru Rock's account, claiming that it is not corroborated. Now, Your Honours, they rely on the Lubanga trial judgment, where they say that it requires evidence that has been corroborated. But Your Honours, in that judgment, that relates to an entirely different stage of proceedings. Lubanga dealt with the trial stage, and here we are only at the pre-trial stage, where there is only reasonable grounds to believe that a crime of enslavement may have been committed. And here we say that there is no need to go into a discussion of or analysis of witnesses' credibility or reliability. And this was clearly held by the trial chamber in its 2016 Tagenda decision because of the low standard of proof. And in any event, Your Honours, it is Lord Blaze's own admission at paragraph 23 that there were atrocities committed at the slave labor camps. Hence, it does not lie in the defense's mouth to now say that there was no acts of enslavement at the labor camps. Now, moving on to my third point in rebuttal. Your Honours, it is true that the pre-trial chamber in the Afghanistan case has held that it can review the interests of justice. But what the defense has failed to inform this court is that the decision has now been overruled. In fact, at paragraph 46 of the appeals chamber judgment, the court clearly held that the pre-trial chamber erred in deciding that an investigation into the situation at this stage would not serve the interests of justice. Hence, it held that the pre-trial chamber should only have addressed whether there is a reasonable factual basis for the prosecutor to proceed, in the sense of whether crimes have been committed and whether potential cases arising from such investigations would fall within this court's jurisdiction. Hence, the defense simply has not provided any legal basis for its challenge to the interests of justice. Now, moving on to the last point in rebuttal, this relates to the defense's argument that inferences made must be the only conclusion. Again, they have made an error of law. Now, in the ICC, there are different standards at different stages of trial. Here, at this stage of the pre-trial, all we need is reasonable grounds to believe, and inferences made must only be one of a number of reasonable conclusions. This was held by this court in its 2011 Al-Bashir decision. Hence, we submit that based on the three factors that we have relied on in the course of my co-counsel's submissions, Lord Blaze has the relevant knowledge that Minister Azila was about to commit crimes of enslavement. And unless I may be of any further assistance to this court.
Thank you very much. If the defense team wants to respond.
Yes, Madam President.
You have the floor.
Thank you. Madam President and Your Excellencies, the defense notes the prosecution's rebuttals and begins with countering the fact that the question raised by the bench in regards to the priests and the children at most only deprived them of their liberty to use language. But what the prosecution has failed to do is establish, as quoted again, time and again by the agent in his earlier submissions, a nexus between these alleged deprivations of liberty and the actual allegation of the crime against humanity of enslavement. The requirement of nexus accrues from this court's judgment time and again. And for instance, prosecutor against Katanga at para 141 and prosecutor against Limage, which also constituted a case of an NIAC, Your Excellencies. And in an NIAC, Madam President and Your Excellencies, the state is afforded the right to derogate from these fundamental liberties pursuant to Article 4 of the International Covenant on Civil and Political Rights. The only two requirements are that there must be a declaration of emergency, which can be seen from the facts at para 8, where Lord Blaze has explicitly laid out an order for the establishment of peace, and it must be demanded by the exigencies of the situation as per Article 4 of the ICCPR, which we submit that it did. Secondly, Madam President and Your Excellencies, the prosecution noted that at the pre-trial stage, Harurok's statement must not be challenged on admissibility. However, this rather rudimentary approach must be corrected at this level by this court for the simple reason that Article 63 of the Rome Statute and the rules of procedure and evidence states that the rules and procedure of evidence, including but not limited to Article 69, which the defense has challenged the admissibility upon, apply to all chambers in all instances, including the pre-trial chamber. And this is precisely why the singular piece of evidence that is being used to prosecute a president of Fire Republic for a grave violation cannot be deemed admissible. With this, the defense rests its case.
Thank you very much. That closes the hearing for today. The judges will now go into the deliberation room. Thank you.
I will now send the judges to the deliberation room and the teams to separate breakout rooms.
Is everyone back? Okay, thank you very much. First of all, thank you very much for all the submissions. I think all of the judges were very impressed, really very impressed. I think you all did an excellent job, both in terms of preparation and in terms of presentation. So what we're now going to do is I'm going to invite comments from my colleague judges. And then after that, we will announce the winner of this particular hearing. So if I may ask Judge Nsereko to provide the comments.
Thank you, Madam President. I reiterate what you've said, that first we congratulate the teams and commend them for their hard work and preparation. I was very impressed by the very high level of advocacy. I think you've been through the grill by this time. You are really done very well, very impressively. And I'm impressed that you have a grasp of the facts. After all, the facts are what you work with when you're appearing in a case, and extremely important. And you appear to know the law and the jurisprudence. I was very happy that when one side cited a decision of one case, the other was able to distinguish it. And this is always extremely helpful to the court, because as lawyers appearing before the court, your duty is to assist them in establishing the law. You did very well. And being involved in international criminal law, I must say I'm heartened by the fact that members of the team are very well conversant with international criminal law, and that there is a future in this field, and that I hope and pray that you are not going to stop at just moot courts, that one day you appear before the real courts and before the real judges here in the city of The Hague and in the other capitals. And I think all of you will do very well, and I hope you will pursue a career in this field. I thank you. One caution though, we all read, we all, when making presentations, we all, of course, have notes, so prepared speeches, and make sure that you do not appear to be reading your speech from your notes all the time, if you can help it. The judges want to see your pupils, and they want to see your animated, making gesticulations. They know that you are really involved. You are not just stuck on the paper. With those comments, Madam President, thank you.
Thank you very much. If I may invite my colleague, Judge Doi, to provide his comments.
Thank you very much. First of all, to both teams, really, your both pleadings are quite impressive. I agree totally so with both other judges, and I found I recognize that you both have very well prepared and learned intensively international criminal law. Also, international criminal law, I think it is still not so common in the national study of law. That's why maybe you spent extensive time for study, maybe for this regard. And the prosecutor, I found your delivery both are quite well. You look very confidential. I found you look so kind of like a professional. Yeah, in that point, I think good point. And the defense counsel, we judges share, so generally, in this case, defense counsel or the tasks of defense counsel is more difficult, maybe. That's why your arguments were actually very creative. That point, I like that. Yeah, and thank you very much to both teams. Yeah, thank you.
Thank you very much. I fully echo what my colleagues already said. I think it's very pleasant to listen to a very structured, not overly structured, but structured presentation. You had a very good pace. All of you actually had a very good pace. And what I also liked is that, of course, we all knew. I mean, I also use notes when I plead before the ICC, but you went on and off sometimes. So you sometimes used your own words, and so that makes it sometimes easier for us as a judge to understand or to be brought back to your presentation. I also thought you did really well in answering the questions, because you didn't answer too long, because you don't have that much time to answer. And sometimes we kept on asking follow-up questions, but you were, all of you were actually quite good in answering the question and then bringing it back to your presentation, which is exactly what you need to do, especially in these competitions, because you have a very limited amount of time, and so you need to use the answer to try to go to your next point. So yeah, no, I think it's nice for us, I think, to see how many young, enthusiastic individuals from all over the world are really learning and studying and really working with international criminal law. So we would certainly like to see you in real life one day at the ICC. Unfortunately, so there's only one team, and it was really close, I think, and I think we all had the same feeling about that. But so we did decide that the prosecution team is the winner of this particular hearing. But as I said, it was very close, and it was a very difficult decision, because you all did really, really well. So thank you.
Thank you so much for the kind words, judges, and good job to the defense. You guys did very well.
And congratulations to the prosecution.
Thank you very much.